April 14, 2023 Relaw. Unit 9 Acquisitions and Conveyances. 1. Ademption. Ademption in real estate refers to the legal principle that occurs when a specific property or asset that was designated to be given to a beneficiary in a will is no longer in the possession or ownership of the testator, the person who made the will, at the time of their death. In other words, if a testator leaves a specific property or asset to a beneficiary in their will, but no longer owns or possesses that property or asset at the time of their death, the gift is said to be adempt and may not pass to the beneficiary as originally intended. Ademption can occur when the testator sells, transfers, or otherwise disposes of the property or asset before their death, or if the property or asset is destroyed or no longer exists. 2. Administrator. An administrator in real estate refers to a person or entity appointed by a court to manage and distribute the estate of a deceased person who died without leaving a valid will, intestate, or without naming an executor in their will. The administrator is responsible for settling the decedent's estate, including identifying and collecting assets, paying debts and expenses, filing necessary tax returns, and distributing the remaining assets to the heirs or beneficiaries according to the laws of intestate succession or court orders. The administrator acts as a fiduciary and must carry out their duties in accordance with applicable laws and court instructions. 3. Adverse possession. Adverse possession in real estate refers to a legal doctrine that allows a person to acquire ownership or title to a property by openly, notoriously, and continuously occupying and using the property for a certain period of time, without the permission or consent of the true owner. The requirements for adverse possession vary by jurisdiction but generally include elements such as actual possession, open and notorious use, exclusive use, continuous use for a statutory period, and hostile or adverse intent to claim ownership. Adverse possession is a complex area of law and may involve legal disputes and court proceedings to determine the validity of the claim. 4. After acquired title. After acquired title in real estate refers to a legal concept that allows a person to acquire or obtain title to a property after they have already conveyed or transferred the property to another party. In other words, if a person sells or transfers a property to another party but subsequently acquires or obtains title to the same property, the after acquired title is automatically transferred to the original grantee or transferee. After acquired title is a legal doctrine that provides protection to the original grantee or transferee against the grantor's or transferor's subsequent acquisition of title to the property. 5. Bequest. A bequest in real estate refers to a gift of real property or other assets made through a will or testamentary document. A bequest is a direction or provision in a will that specifies how a testator's property or assets are to be distributed after their death. A bequest may involve transferring real property, personal property, money, or other assets to a named beneficiary or beneficiaries, and may be subject to certain conditions or limitations as specified in the will. Bequests are typically made in accordance with the testator's wishes and are subject to the laws of wills and estates in the jurisdiction where the will is probated. 6. Codicil. A codicil in real estate refers to a legal document that amends or modifies a previously executed will. A codicil is a separate document that is executed with the same formalities as a will and is used to make changes or additions to a will without revoking or replacing the entire will. A codicil may be used to change beneficiaries, modify gift provisions, revoke or add powers of appointment, or make other changes to a will. 1. Color of title. Color of title in real estate refers to a claim or appearance of ownership to a property based on a document or instrument that appears to convey valid title, but may be defective or insufficient in some way. Color of title may arise from a deed, contract, or other document that purports to transfer ownership of the property, but may have defects such as missing signatures, incorrect descriptions, or other irregularities that may affect its validity. A person claiming color of title may have a legal basis to assert ownership or seek remedies related to the property, but the claim is not considered clear or marketable title until any defects are resolved. 2. Dedication. Dedication in real estate refers to the transfer of ownership or control of a property, usually land, from a private owner to a public entity or the public at large for a specific public use or purpose. Dedication typically involves a voluntary act by the property owner, and may be done through a formal process that requires certain legal formalities to be met. For example, a property owner may dedicate a portion of their land as a public park, road, or easement, thereby giving up their rights of ownership and allowing the public or a public entity to use and maintain the dedicated portion of the property for the designated purpose. 3. Deed. A deed in real estate is a legal document that conveys ownership or title to a property from one party, the grantor, to another party, the grantee. A deed typically includes a description of the property being conveyed, the names of the parties involved, the granting clause, and any governance or conditions related to the transfer of ownership. Deeds may come in various forms, such as warranty deeds, quitclaim deeds, special warranty deeds, or bargain and sale deeds. and the type of deed used may affect the rights and protections of the parties involved. Deeds are typically recorded in the appropriate county or jurisdiction where the property is located to provide notice of the transfer of ownership. 4. Devise. Devise in real estate refers to the transfer of real property through a will or testamentary document. A devise is a gift of real property made in a will by the testator, the person who made the will, to a named beneficiary or beneficiaries. A devise may involve the transfer of fee simple ownership, a life estate, or other interests in real property, and may be subject to certain conditions or limitations as specified in the will. Devisees are the beneficiaries who receive the real property through the devise, and their rights and interests in the property are determined by the terms of the will and applicable laws of wills and estates. 5. Eminent domain. Eminent domain in real estate refers to the power of a government or public entity to take private property for a public purpose, such as for the construction of public infrastructure, redevelopment projects, or other public uses. Eminent domain is a legal process that involves the government or public entity compensating the property owner for the fair market value of the property taken, and may involve negotiations, appraisals, and court proceedings to determine the appropriate compensation. Eminent domain is subject to constitutional limitations and procedural safeguards, and property owners have the right to challenge the taking and seek just compensation for their property. 6. Escheat. Escheat in real estate refers to the transfer of ownership or title to a property to the state or government when the property owner dies without leaving a valid will or without known heirs to inherit the property. Escheat is a legal doctrine that allows the state or government to claim ownership of abandoned or unclaimed property in order to prevent property from being left in limbo or becoming a public burden. Escheat typically occurs after a legal process that involves efforts to locate and notify potential. 1. Exception in a deed. An exception in a deed in real estate refers to a provision or clause that excludes or reserves certain rights, interests, or property from the scope of the deed. An exception typically limits the extent of the property being conveyed in a deed and may specify certain rights or interests that are retained by the grantor or excluded from the transfer. For example, a deed may include an exception for an easement that allows the grantor or a third party to continue using a portion of the property for a specific purpose, or it may exclude certain mineral rights or other interests from the conveyance. 2. Executor. An executor in real estate refers to a person who is appointed in a will to administer the estate of a deceased person and carry out the provisions of the will. An executor is responsible for managing the assets, debts, and distribution of property in the estate according to the terms of the will and applicable laws of wills and estates. In the context of real estate, the executor may be responsible for transferring ownership or title to real property to the beneficiaries or heirs as specified in the will, and may have legal authority to sign deeds, contracts, and other documents on behalf of the estate. 3. Formal will. A formal will in real estate refers to a legally executed and witnessed written document that sets forth the wishes of a testator, the person making the will, regarding the distribution of their property after their death. A formal will typically must meet certain legal requirements, such as being in writing, signed by the testator, and witnessed by 2 or more disinterested witnesses, in order to be valid and enforceable. A formal will may include provisions related to real estate, such as the devise of specific properties, the appointment of an executor, and other instructions related to the disposition and management of real property. 4. Gift deed. A gift deed in real estate refers to a legal document that conveys ownership or title to a property from one party, the donor, to another party, the doned, without the exchange of consideration or payment. A gift deed typically involves a voluntary transfer of property as a gift, and may require certain legal formalities, such as being in writing, signed by the donor, and recorded in the appropriate county or jurisdiction where the property is located. Gift deeds may be used to transfer real property between family members, friends, or other parties, and may be subject to gift tax implications and other legal considerations. 5. Grant deed. A grant deed in real estate refers to a legal document that conveys ownership or title to a property from one party, the grantor, to another party, the grantee. A grant deed typically includes warranties or covenants by the grantor that affirm the grantor's ownership of the property and guarantee that the property is free from certain encumbrances, except as otherwise specified in the deed. Grant deeds are commonly used in many states in the United States as a means of transferring ownership of real property, and may be recorded in the appropriate county or jurisdiction where the property is located to provide notice of the transfer of ownership. 6. Holographic will. A holographic will in real estate refers to a handwritten and signed document that sets forth the wishes of a testator regarding the distribution of their property after their death. A holographic will may not be witnessed or executed with the same formalities as a formal will, but may be valid and enforceable in certain jurisdictions if it meets the requirements of applicable laws of wills and estates. Holographic wills may be used in situations where a testator wants to express their wishes regarding the disposition of their property but may not have access to or choose to use a formal will. However, Holographic wills may be subject to greater scrutiny. 1. Independent Administration of Estates Act. The Independent Administration of Estates Act, IAEA, is a legal statute or law that governs the administration of estates of deceased persons in certain jurisdictions. The IAEA provides for a simplified and streamlined process for the administration of estates, allowing for more efficient and expedited settlement of estates without the need for court supervision or approval. The IAEA typically grants greater powers and authority to the executor or administrator of an estate, including the ability to sell, manage, and distribute estate assets without court intervention, subject to certain statutory requirements and limitations. 2. Intestate succession. Intestate succession in real estate refers to the legal process by which the property of a deceased person who died without a valid will or other testamentary document is distributed to their heirs according to the laws of inheritance or succession in the applicable jurisdiction. In the absence of a will, the property of the deceased person is distributed to their heirs in a manner determined by the laws of the jurisdiction, typically based on the degree of relationship or kinship to the deceased person. Intestate succession may involve the transfer of ownership or title to real property to the legal heirs of the deceased person, according to the laws of the jurisdiction. 3. Inverse condemnation. Inverse condemnation in real estate refers to a legal doctrine or action by which a property owner seeks compensation or damages from a governmental entity or agency for the taking or damaging of their property for public use without formal condemnation proceedings being initiated by the government. Inverse condemnation may arise when a government action or regulation results in the devaluation or deprivation of property rights, and the property owner seeks compensation or damages for the loss suffered. Inverse condemnation may involve claims related to eminent domain, zoning regulations, land use restrictions, or other governmental actions that impact the value or use of real property. 4. Marketable title. Marketable title in real estate refers to a clear and marketable ownership or title to a property that is free from any reasonable doubt or defect and can be readily sold or transferred to another party. Marketable title typically means that the ownership or title to the property is free from any liens, encumbrances, defects, or claims that may impair the ability of the owner to convey or transfer the property to another party. Marketable title is often a requirement in real estate transactions, as it provides assurance to buyers, lenders, and other parties that the property is free from any unresolved legal issues or claims that may impact the value or transferability of the property. 5. Pursterps. Pursterps in real estate refers to a method of distributing property or assets among heirs or beneficiaries in a will or other testamentary document based on the representation of a deceased person's share by their descendants. Pursterps typically involves the division of a deceased person's share equally among their living descendants at the same generational level, with the share of any deceased descendant being divided equally among their own descendants. Pursterps distribution may be used in situations where a beneficiary or heir predeceases the testator or owner of the property, and their share is passed on to their own descendants in the distribution of the estate or property. 6. Police power. Police power in real estate refers to the inherent authority and power of the government to regulate and control the use of land and property in order to protect the health, safety, welfare, and general public interest of the community. Police power allows the government to enact and enforce laws, regulations, and zoning ordinances that govern land use, building codes, environmental protection, public health, and other matters related to the use and development of real property. Police power may restrict or regulate the rights and interests of property owners in order to promote the public good and ensure the orderly and responsible development and use of land and property within a jurisdiction. 1. Probate. Probate in real estate refers to the legal process by which a deceased person's estate is administered, including the settlement of their debts, payment of taxes, and distribution of assets, including real property, according to the terms of their will or the laws of intestate succession in the applicable jurisdiction. Probate is typically supervised by a court and involves the identification, valuation, and distribution of the deceased person's assets, including any real estate holdings. Probate may be required when a person dies with a will, testate, or without a will, intestate, and the process may vary depending on the laws and procedures of the jurisdiction where the probate is administered. 2. Proposition 99. Proposition 99 is a California state law that was passed in 1988 as a voter-initiated ballot measure to protect private property rights and limit the government's power of eminent domain. Proposition 99 amended the California Constitution to prohibit the government from taking or damaging private property for private use, including economic development or private commercial purposes. Proposition 99 also provides certain protections for property owners, including fair market value compensation for property taken or damaged by eminent domain, and limitations on the government's ability to transfer property taken by eminent domain to private entities. 3. Quitclaim deed. A quitclaim deed in real estate is a legal document used to transfer or convey ownership or interest in a property from one party, grantor, to another party, grantee, without making any warranties or guarantees about the title or condition of the property. A quitclaim deed only transfers whatever interest or claim the grantor may have in the property, without providing any assurances about the validity of the title or the existence of any liens, encumbrances, or defects. Quitclaim deeds are commonly used in situations where there is a transfer of property between family members, changes in ownership or co-ownership, or when a party wants to release or convey their interest in a property without assuming any liability or responsibility for the property. 4. Reservation in a deed. A reservation in a deed in real estate refers to a clause or provision in a deed that reserves certain rights, interests, or privileges for the grantor or another party, even after the transfer or conveyance of the property to the grantee. A reservation in a deed may include rights such as mineral rights, water rights, easements, or other interests that are retained by the grantor or reserved for another party. Reservations in deeds are typically recorded in the public records and may impact the use, development, or value of the property, as they may impose restrictions or limitations on the grantee's ownership or rights in the property. 5. Sheriff's deed. A sheriff's deed in real estate is a legal document that is issued by a sheriff or other authorized law enforcement officer as a result of a court-ordered sale of property to satisfy a judgment or lien. Sheriff's deeds are typically used in situations where a property is sold at a public auction or sheriff's sale, usually as a result of a foreclosure or other legal process, to satisfy a debt or obligation owed by the property owner. Sheriff's deeds transfer ownership or title to the property from the defaulting owner, judgment debtor, to the highest bidder or purchaser at the sheriff's sale, and may be subject to certain conditions or restrictions depending on the laws and procedures of the jurisdiction where the sale takes place. 6. Simultaneous death. Simultaneous death in real estate refers to a legal doctrine or concept that is used to determine the distribution or succession of property when two or more persons die at the same time or within a short period of time, and their deaths cannot be determined to have occurred in any particular order. Simultaneous death may occur in situations where 1. Tacking on. In real estate, tacking on refers to the concept of adding or combining successive periods of adverse possession by different individuals to establish a continuous period of adverse possession required to obtain legal ownership or title to a property. This concept allows for the accumulation of time spent in adverse possession by different parties to meet the statutory requirements for adverse possession, which typically include a continuous, uninterrupted, open, notorious, and hostile possession of the property for a certain period of time. 2. Tax deed. A tax deed in real estate is a legal document that is issued by a governmental entity, such as a county or municipality, as a result of a property owner's failure to pay property taxes. A tax deed conveys ownership or title of the property from the delinquent owner to the governmental entity or to a third-party purchaser who acquires the property through a tax sale. Tax deeds are typically used as a means for local governments to collect unpaid property taxes and may have specific legal requirements and procedures that vary by jurisdiction. 3. Trustee's deed. A trustee's deed in real estate is a legal document that is executed by a trustee, who holds legal title to a property on behalf of another person or entity, and conveys ownership or title of the property to a third party. Trustee's deeds are commonly used in situations where a property is held in a trust, such as a revocable living trust, and the trustee is authorized to sell or transfer the property according to the terms of the trust agreement. Trustee's deeds typically include provisions that outline the powers and responsibilities of the trustee, as well as any restrictions or conditions on the transfer of the property. 4. Valid will. In real estate, a valid will refers to a legally enforceable document that sets forth a person's wishes regarding the distribution of their property and assets after their death. A valid will must comply with the statutory requirements of the jurisdiction where it is executed, which typically include the testator's, person making the will, capacity, intent, and signature, as well as the presence of witnesses and formalities such as notarization. A valid will may include provisions that specifically address the distribution of real estate, such as bequests or devises of specific properties, and may impact the transfer or conveyance of real estate after the testator's death. 5. Warranty deed. A warranty deed in real estate is a legal document that conveys ownership or title of a property from a seller, grantor, to a buyer, grantee, and includes certain warranties or guarantees about the title and condition of the property. A warranty deed typically includes covenants or promises made by the seller to the buyer, such as the covenant of cession, guaranteeing that the seller has legal ownership and the right to convey the property, the covenant of quiet enjoyment, guaranteeing that the buyer's possession and use of the property will not be disturbed by third-party claims, and the covenant against encumbrances, guaranteeing that the property is free from liens, mortgages, or other encumbrances, except as specifically disclosed in the deed. Warranty deeds provide greater protection and assurances to buyers than other types of deeds, as they warrant the title and condition of the property. 6. Will. In real estate, A will refers to a legal document that sets forth a person's wishes regarding the distribution of their property and assets after their death. A will may include provisions that specifically address the transfer or conveyance of real estate, such as bequests or devises of specific properties, and may impact the ownership, title, or use of real estate after the testator's death. A will must comply with the statutory requirements of the jurisdiction where it is executed. Unit 10 Real Property Security Devices. 1. Annual Percentage Yield, APY. Annual Percentage Yield, APY, is a financial term used in real estate to represent the effective annual rate of return on an investment, taking into account the effects of compounding interest over a one-year period. APY is calculated by considering not only the nominal interest rate but also the frequency of compounding and any fees or charges associated with the investment. APY is commonly used in the context of mortgage loans, savings accounts, and other financial products to provide a more accurate representation of the true return or cost of an investment. 2. Anti-merger clause. An anti-merger clause, also known as a no-merger clause or a prohibition on consolidation clause, is a contractual provision often found in real estate agreements or contracts, such as leases or purchase agreements. This clause prohibits the consolidation or merger of different properties or interests, typically to prevent the loss of certain rights or benefits that may be associated with separate ownership or to maintain the parties' original intentions or arrangements. Anti-merger clauses are used to ensure that the parties' respective rights, obligations, or interests in the real estate are preserved and not inadvertently combined or extinguished through a merger or consolidation. 3. Assignment of rent. Assignment of rent is a legal document or provision in a real estate agreement that allows a landlord or lender to assign or transfer the right to collect rent payments from a tenant or borrower to a third party. This assignment of rent can be used as security for a loan or other financial obligation, and typically requires the tenant or borrower to make rent payments directly to the assigned party. Assignment of rent clauses are commonly used in commercial real estate leases or mortgage agreements as a means of securing the landlord or lender's rights to collect rent in the event of default or non-payment. 4. Bait-and-switch advertising. Bait-and-switch advertising is a deceptive marketing practice that involves advertising a product or service at a low price or with attractive terms to lure potential customers, and then substituting or switching the advertised product or service with a different, often less favorable, product or service once the customer expresses interest or makes a commitment. Bait-and-switch advertising is generally considered unethical and may be illegal in many jurisdictions, as it can mislead consumers and result in unfair or deceptive trade practices in the real estate industry. 5. Balloon payment. A balloon payment is a large, lump sum payment that becomes due at the end of a loan term or at a specified time period, typically in real estate financing. Balloon payments are often associated with certain types of mortgage loans or other financing arrangements where the borrower makes smaller periodic payments over the loan term, but is required to pay off the remaining balance in one large payment at the end of the term. Balloon payments can be risky for borrowers, as they may require a significant amount of money to be paid at once, and may require additional refinancing or payment arrangements to fulfill the obligation. 6. Beneficiary statement. A beneficiary statement, also known as a payoff statement or a loan payoff letter, is a document provided by a lender to a borrower or to a third party, such as an escrow agent or a title company, that details the outstanding balance, interest rate, and other relevant information of a loan or mortgage. Beneficiary statements are commonly used in real estate transactions, such as when a property is being sold or refinanced, to provide an accurate payoff amount that is required to satisfy the loan and release the lender's lien or encumbrance on the property. Beneficiary statements are typically obtained from the lender or mortgage servicer upon request and may include information on any prepayment penalties, escrow balances, or other fees or charges associated with the loan. 1. Blanket encumbrance. A blanket encumbrance, also known as a blanket lien or a blanket mortgage, is a type of lien or encumbrance that covers multiple properties or assets owned by the same party. In real estate, a blanket encumbrance may be used to secure a loan or other financial obligation by creating a single lien or encumbrance that applies to multiple properties or assets, rather than creating separate liens or encumbrances for each individual property or asset. Blanket encumbrances are commonly used in commercial real estate transactions, such as when a borrower owns multiple properties that are being used as collateral for a single loan, and may provide flexibility in managing and financing multiple properties or assets together. 2. California Homeowners Bill of Rights. The California Homeowners Bill of Rights is a set of laws and regulations that provide certain protections and rights to homeowners in the state of California. Enacted in 2013, the California Homeowners Bill of Rights aims to prevent unfair and abusive practices by lenders and servicers in the mortgage and foreclosure process, and includes provisions related to loan modifications, foreclosure procedures, and borrower rights. The California Homeowners Bill of Rights is designed to provide additional protections to homeowners facing financial difficulties and to promote transparency and fairness in the residential mortgage market. 3. California Housing Financial Discrimination Act of 1977. The California Housing Financial Discrimination Act of 1977 is a state law in California that prohibits discrimination in housing based on certain protected characteristics, including race, color, religion, sex, marital status, national origin, ancestry, familial status, disability, and sexual orientation. The act applies to a wide range of housing-related transactions, such as the sale, rental, financing, or provision of services related to housing, and is designed to promote fair housing practices and prevent discrimination in the housing market in California. 4. Certificate of Sale. A certificate of sale is a document issued by a court or other authorized entity that serves as evidence of the sale of a property or asset through a foreclosure or tax sale. In real estate, a certificate of sale is typically issued after a property has been sold at a foreclosure auction or tax sale due to default on a loan or failure to pay property taxes. The certificate of sale may include information about the property, the sale price, the date of sale, and other relevant details, and is often used as proof of ownership or transfer of the property to the successful bidder or buyer. 5. Controlled Business Arrangement. A controlled business arrangement, CBA, is a term used in the context of the Real Estate Settlement Procedures Act, RESPA, a federal law in the United States that regulates certain real estate transactions, including residential mortgage loans. ICBA refers to a business arrangement where a person or entity involved in a real estate transaction, such as a lender, real estate broker, or title company, has a financial interest or ownership in a settlement service provider, such as an appraisal company or a mortgage insurance company. CBAs are subject to certain disclosure and other requirements under RESPA to promote transparency and prevent conflicts of interest that could harm consumers. 6. Defeasance Clause. A defeasance clause is a provision in a mortgage or other loan agreement that allows the borrower to obtain a release of the mortgage or loan lien upon satisfying certain conditions, typically by repaying the loan in full. In real estate, a defeasance clause may be included in a mortgage or other financing agreement to provide a mechanism for releasing the property from the lien once the loan has been fully paid off, typically by depositing funds or securities into an escrow account or by obtaining a substitute collateral. Defeasance clauses are often used in commercial real estate transactions to provide flexibility for borrowers and lenders. 1. Deficiency Judgment. A deficiency judgment is a legal judgment that may be obtained by a lender against a borrower who defaults on a mortgage or other loan secured by real estate, and the proceeds from the sale of the property are insufficient to fully satisfy the outstanding debt. In other words, it is the difference between the amount owed on the loan and the proceeds obtained from the sale of the property. A deficiency judgment allows the lender to seek repayment of the remaining debt from the borrower's other assets or income, subject to applicable laws and regulations. 2. Dodd-Frank Act. The Dodd-Frank Wall Street Reform and Consumer Protection Act, commonly known as the Dodd-Frank Act, is a federal law enacted in 2010 in the United States in response to the 2008 financial crisis. The Dodd-Frank Act introduced significant reforms to the financial services industry, including regulations aimed at improving transparency, accountability, and consumer protection in various aspects of the financial markets, including real estate lending and mortgage practices. The Dodd-Frank Act established the Consumer Financial Protection Bureau, CFPB, and implemented various rules and requirements related to mortgage lending, appraisal practices, loan originator compensation, and more. 3. Dragnet Clause. A dragnet clause, also known as a blanket clause or an all-inclusive clause, is a provision in a mortgage or other loan agreement that extends the security interest to cover not only the initial loan or indebtedness, but also any future loans, advances, or obligations that may be incurred by the borrower and secured by the same property. In other words, a dragnet clause allows a lender to drag or extend the security interest to cover additional loans or obligations without having to create a new mortgage or security instrument. Dragnet clauses are commonly used in commercial real estate lending to provide flexibility for future financing arrangements. 4. Due on sale clause. A due on sale clause, also known as an acceleration clause or an alienation clause, is a provision in a mortgage or other loan agreement that allows the lender to accelerate the repayment of the loan if the borrower sells, transfers, or otherwise conveys the property securing the loan to a third party. In other words, a due on sale clause gives the lender the right to demand immediate repayment of the entire loan balance upon the sale or transfer of the property, regardless of whether the borrower is in default. Due on sale clauses are commonly used in real estate lending to protect the lender's interest in the property and ensure that the loan is repaid upon transfer of ownership. 5. Equal Credit Opportunity Act. The Equal Credit Opportunity Act, ECA, is a federal law in the United States that prohibits discrimination in credit transactions based on certain protected characteristics, including race, color, religion, sex, marital status, national origin, age, receipt of public assistance, and exercise of rights under the Consumer Credit Protection Act. The ECA applies to a wide range of credit transactions, including loans, credit cards, and other forms of credit, and requires lenders and creditors to provide equal opportunity and fair treatment to all applicants, regardless of their protected status. 6. Fair Credit Reporting Act. The Fair Credit Reporting Act, FCRA, is a federal law in the United States that regulates the collection, use, and disclosure of consumer credit information by credit reporting agencies, as well as the rights and responsibilities of consumers in relation to their credit reports. The FCRA sets forth requirements for the accuracy, privacy, and security of credit information, and provides consumers with certain rights, including the right to obtain a free copy of their credit report, dispute inaccuracies, and receive notice of adverse actions taken based on their credit reports. The FCRA also imposes obligations on lenders, creditors, and other entities that use credit reports for decision-making purposes, including in the context. 1. Fictitious trust deed. A fictitious trust deed, also known as a false trust deed or a fraudulent trust deed, is a document that purports to be a valid trust deed but is not authorized or executed by the true property owner or by a party with proper legal authority. Fictitious trust deeds are typically created with the intent to defraud, deceive, or otherwise commit illegal activities related to real estate, such as obtaining loans or encumbering property without the true owner's knowledge or consent. Fictitious trust deeds are considered void and unenforceable, and those who knowingly create or use fictitious trust deeds may be subject to civil and criminal penalties. 2. Financing statement. A financing statement, also known as a UCC-1 financing statement, is a legal document filed with a state or local government agency to publicly notify creditors of a security interest in personal property. In the context of real estate, a financing statement may be filed to establish a security interest in fixtures or other personal property that is attached to or used in connection with real property. A financing statement typically includes information about the debtor, the secured party, and the collateral, and serves as notice to other creditors that a security interest has been claimed in the specified property. 3. GARN Act. The Garn Street Germain Depository Institutions Act, commonly known as the GARN Act, is a federal law enacted in 1982 in the United States that provides certain exemptions and exceptions to the due on sale clause in residential mortgages. The GARN Act allows for limited circumstances in which a borrower can't transfer their property without triggering the acceleration of the mortgage loan, such as transfers to certain family members, transfers to a spouse upon death, or transfers to a living trust. The GARN Act also contains provisions related to the treatment of assumable loans, escrow accounts, and disclosure requirements for lenders. 4. Holder in due course. A holder in due course is a legal term that refers to a person who acquires a negotiable instrument, such as a promissory note or a check, in good faith, for value, and without notice of any defects or claims against the instrument. A holder in due course is entitled to certain legal protections and rights, including the right to enforce the instrument against the parties liable on it, regardless of any claims or defenses that may exist between the original parties. In the context of real estate, a holder in due course of a promissory note secured by a mortgage may have priority over other claims or interests in the property. 5. Hypothecate. Hypothecate is a legal term that refers to pledging property, typically real property, as security for debt or obligation without transferring ownership of the property. When a property is hypothecated, the debtor retains ownership of the property but gives the creditor a security interest in the property to secure the debt. If the debtor defaults on the debt, the creditor may have the right to foreclose on the property and satisfy the debt from the proceeds of the sale. Hypothecation is commonly used in real estate financing, such as in mortgage loans where the property serves as collateral for the loan. 6. Loan estimate. A loan estimate is a disclosure required by the Consumer Financial Protection Bureau, CFPB, under the Federal Real Estate Settlement Procedures Act, RESPA, in the United States. It is a standardized form that provides borrowers with detailed information about the terms, costs, and estimated payments of a mortgage loan. The loan estimate must be provided by lenders to borrowers within a certain time frame after the borrower applies for a mortgage loan, and it is intended to help borrowers compare loan offers from different lenders and make informed decisions about their mortgage options. The loan estimate includes information about the loan amount, interest rate, closing costs. 1. Lock-in clause. A lock-in clause, also known as a rate lock or rate locking clause, is a provision in a mortgage loan agreement that allows the borrower to secure a specific interest rate for a certain period of time, usually until the loan closes. Once a locking clause is activated, the lender is obligated to honor the locked-in interest rate, even if market interest rates fluctuate during the locking period. Lock-in clauses provide borrowers with protection against potential interest rate increases, but they may also impose restrictions and fees if the borrower chooses to modify or cancel the locked-in rate before the loan closes. 2. Mortgage. A mortgage is a legal document that serves as a security instrument in a real estate transaction. It is a loan agreement between a borrower, also known as the mortgager, and a lender, also known as the mortgagee, in which the borrower pledges a property as collateral for the loan. The mortgage gives the lender a security interest in the property, which allows the lender to foreclose on the property and sell it to satisfy the debt if the borrower defaults on the loan. The mortgage typically includes terms such as the loan amount, interest rate, repayment terms, and provisions for insurance and taxes. 3. Mortgage Forgiveness Debt Relief Act. The Mortgage Forgiveness Debt Relief Act is a federal law enacted in 2007 in the United States that provides certain tax relief to borrowers who have had a portion of their mortgage debt forgiven or canceled by a lender. Under normal circumstances, forgiven mortgage debt is considered taxable income by the IRS, and borrowers may be required to pay taxes on the amount of debt forgiven. However, the Mortgage Forgiveness Debt Relief Act provides an exemption from federal income tax for qualified mortgage debt forgiven or canceled between 2007 and 2020, subject to certain limitations and qualifications. 4. Negotiable Instruments. Negotiable instruments are written documents that represent a promise or order to pay a specific amount of money and can be transferred from one party to another. In the context of real estate, negotiable instruments are commonly used in mortgage transactions, where a promissory note is executed by the borrower as evidence of the debt and is transferred to the lender in exchange for a loan. Negotiable instruments are subject to certain legal requirements and regulations, and they are generally freely transferable and enforceable by the holder in due course. 5. Notice of Delinquency. A notice of delinquency is a written notification provided by a lender or a mortgage servicer to a borrower who has failed to make timely payments on a mortgage loan. The notice of delinquency typically informs the borrower of the amount past due, the due date of the missed payment, and the consequences of continued delinquency, such as late fees, penalties, and potential foreclosure proceedings. Notice of delinquency is an important step in the foreclosure process, and it serves as a formal notification to the borrower that their loan is in default. 6. Obligatory advances. Obligatory advances, also known as advances on a construction loan, are funds that a lender is required to disburse to a borrower during the construction or improvement of a property. Obligatory advances are typically provided in stages or draws, based on the progress of the construction or improvement project, and are intended to cover the cost of labor and materials. The terms and conditions for obligatory advances are typically outlined in the loan agreement, and the borrower may be required to provide evidence of progress and compliance with the construction plans before the lender disburses the funds. Obligatory advances are common in construction loans, where the lender releases funds as the project progresses and the value of the property increases. 1. Or more clause. An or more clause, also known as an escalation or acceleration clause, is a provision in a real estate contract that allows for an increase or acceleration of certain terms or conditions. In the context of real estate, an or more clause may be used in various situations, such as in a lease agreement to provide for rent increases over time, or in a purchase agreement to allow for adjustments in purchase price or other terms based on certain events or conditions. The specific terms and conditions of an or more clause are typically negotiated and agreed upon by the parties involved in the contract. 2. Partially amortized note. A partially amortized note is a type of promissory note used in real estate financing that requires the borrower to make regular payments of principal and interest over a specified period of time, but does not fully amortize or repay the loan by the end of the term. As a result, at the end of the loan term, there may be a remaining balance, also known as a balloon payment, that is due in full. Partially amortized notes are often used in situations where the borrower expects to have sufficient funds or intends to refinance or sell the property before the balloon payment becomes due. 3. Predatory lending. Predatory lending refers to unethical, deceptive, or unfair lending practices by lenders that take advantage of vulnerable borrowers, often in the context of real estate transactions. Predatory lending practices may include excessive fees, high interest rates, prepayment penalties, balloon payments, and other terms that may result in financial harm or loss to borrowers. Predatory lending is generally considered to be harmful and may be illegal under applicable laws and regulations. It is important for borrowers to be aware of their rights and to carefully review and understand the terms of any loan agreement to avoid falling victim to predatory lending practices. 4. Promissory note. A promissory note is a written document that represents a promise by one party, the borrower or maker, to repay a specific amount of money to another party, the lender or payee, usually with interest, over a specified period of time. Promissory notes are commonly used in real estate transactions as evidence of a debt and the terms of repayment, and they may be secured by a mortgage or other form of collateral. Promissory notes typically include terms such as the loan amount, interest rate, repayment terms, late fees, and other provisions that outline the rights and responsibilities of the borrower and lender. 5. Real Estate Settlement Procedures Act. The Real Estate Settlement Procedures Act, RESPA, is a federal law in the United States that sets forth certain requirements and procedures for real estate transactions involving residential properties. RESPA is designed to protect consumers by ensuring transparency, fairness, and accuracy in the settlement process, which includes the closing of a real estate transaction. RESPA requires lenders to provide borrowers with certain disclosures, such as the loan estimate and closing disclosure, which provide detailed information about the terms, costs, and fees associated with a mortgage loan. RESPA also regulates the use of escrow accounts, the handling of loan servicing, and prohibits certain practices, such as kickbacks and referral fees. 6. Real Property Sales Contract. A real property sales contract, also known as a purchase agreement or contract of sale, is a legally binding agreement between a buyer and a seller for the sale of real estate. The real property sales contract outlines the terms and conditions of the sale, including the purchase price, payment terms, contingencies, and deadlines for performance. Once both parties have agreed to the terms and signed the contract, it becomes legally binding and sets forth the rights and responsibilities of the buyer and seller with respect to the sale of the property. Real property sales. 1. Rent skimming. Rent skimming refers to an illegal practice in real estate where a person, typically a landlord or property owner, collects rent from tenants for a property but fails to use those funds for their intended purpose, such as paying the mortgage, property taxes, or maintenance expenses. Instead, the collected rent is skimmed or kept by the landlord or property owner for personal gain, without fulfilling their obligations as a property owner. Rent skimming is considered fraudulent and can result in legal repercussions, including civil and criminal penalties. 2. Request for Notice of Default. A request for notice of default is a formal written request made by a party, typically a lien holder or a junior creditor, to the trustee or lender in a mortgage or deed of trust, asking to be notified in the event that the borrower defaults on the loan secured by the property. The request for notice of default is a way for the party making the request to stay informed about the status of the loan and any potential default by the borrower, allowing them to take appropriate action to protect their interests, such as initiating foreclosure proceedings or seeking remedies under applicable laws. 3. Right of redemption. Right of redemption is a legal concept that allows a borrower or homeowner who has defaulted on a mortgage or deed of trust to reclaim their property by repaying the outstanding debt, along with any additional costs or fees, within a specified period of time after a foreclosure sale or other form of involuntary sale. The right of redemption is typically provided by state laws and may vary depending on the jurisdiction and type of foreclosure process used. The right of redemption provides a last opportunity for the borrower to regain ownership of the property and avoid complete loss of their investment. 4. Security Agreement. A security agreement is a legal contract between a debtor, usually a borrower, and a secured party, usually a lender, that creates a security interest in personal property, such as equipment, inventory, or other assets, as collateral for a loan or other obligation. The security agreement outlines the terms and conditions of the secure transaction, including the description of the collateral, the rights and responsibilities of the debtor and secured party, and the procedures for enforcing the security interest in the event of default. A security agreement is typically executed in writing and may be recorded or filed with the appropriate government agency to establish the priority of the security interest against other creditors. 5. Service Members Civil Relief Act. The Service Members Civil Relief Act, SCRA, is a federal law in the United States that provides certain legal protections and benefits to active duty military personnel and their families in various civil matters, including real estate transactions. The SCRA is designed to alleviate legal and financial burdens on service members during their active duty period and provides protections against foreclosure, eviction, default judgments, and other legal actions. The SCRA also provides interest rate and lease termination protections, as well as other rights and benefits to qualifying service members and their dependents. 6. Subject to. Subject to is a term used in real estate transactions to refer to a situation where a buyer acquires a property subject to the existing mortgage or other encumbrances, without assuming or guaranteeing the debt. In other words, the buyer takes over ownership of the property but does not become personally liable for the existing mortgage or encumbrances. The buyer may continue to make payments on the existing mortgage or encumbrances, or may negotiate new terms with the lender, but the original borrower remains responsible for the debt. Subject to transactions require careful review of the existing loan documents and may involve certain risks and legal considerations. 1. Trust deed. A trust deed, also known as a deed of trust, is a legal document used in real estate transactions to create a security interest in real property as collateral for a loan. It involves three parties: the borrower, also called the trustor, the lender, also called the beneficiary, and a neutral third party known as the trustee. The trust deed is recorded in the public records and provides the lender with a security interest in the property, allowing them to foreclose on the property in the event of borrower default. Once the loan is repaid, the trustee reconveys the property back to the borrower. Trust deeds are commonly used as a method of securing real estate loans in many states in the United States. 2. Truth in Lending Act. The Truth in Lending Act, TILA, is a federal consumer protection law in the United States that requires lenders to disclose certain key terms and costs of credit to borrowers in consumer credit transactions. TILA is designed to promote transparency and fairness in lending practices and ensure that borrowers are provided with accurate and meaningful information about the costs and terms of credit, including the annual percentage rate, APR, finance charges, total loan amount, payment schedule, and other important details. TILA applies to various types of credit transactions, including mortgage loans, auto loans, credit cards, and other forms of consumer credit. 3. Truth in Savings Act. The Truth in Savings Act, TISA, is a federal law in the United States that requires depository institutions, such as banks and credit unions, to provide clear and accurate disclosures to consumers about the terms and conditions of deposit accounts, including savings accounts, checking accounts, and other types of deposit products. TISA is designed to promote transparency and fairness in the disclosure of fees, interest rates, and other account features, allowing consumers to make informed decisions when choosing deposit accounts. TISA requires depository institutions to provide disclosures in a uniform format and at specified times, and also sets forth rules related to advertising, account statements, and other consumer protections. 4. Wraparound Loan. A wraparound loan, also known as an all-inclusive trust deed, 8, or wraparound mortgage, is a type of financing arrangement in real estate where a buyer obtains a new loan from a seller that includes the outstanding balance of the seller's existing mortgage. The buyer makes payments to the seller, who in turn continues to make payments on the existing mortgage. The wraparound loan wraps around the existing mortgage, combining it with a new loan, and the buyer makes a single payment to the seller for both loans. Wraparound loans are often used as a creative financing option in situations where the buyer is unable to obtain traditional financing or wants to take advantage of favorable terms offered by the seller. However, wraparound loans involve certain risks and legal considerations, and parties should seek professional advice before entering into such arrangements. Unit 11 Involuntary Liens and Homesteads. 1. Abstract of Judgment. An abstract of judgment is a document that summarizes a court's judgment in a lawsuit and creates a lien against the real property owned by the judgment debtor. It is typically recorded in the public records in the county where the property is located, and serves as a notice to potential buyers, lenders, and other interested parties that there is an outstanding judgment against the property owner. An abstract of judgment typically includes information such as the names of the parties, the amount of the judgment, the court where the judgment was entered, and the date of the judgment. 2. Ad valorem taxes. Ad valorem taxes are taxes levied on real property based on its assessed value. The term ad valorem is Latin for according to value, and ad valorem taxes are calculated as a percentage of the assessed value of the property. Ad valorem taxes are used by local governments, such as counties and municipalities, to fund various public services and facilities, such as schools, roads, parks, and law enforcement. The assessed value of a property is typically determined by the local tax assessor, based on the property's fair market value and applicable tax rates. 3. Affirmation. In real estate, affirmation refers to a formal declaration or confirmation of the validity or truthfulness of a document or statement. It is typically used in the context of legal or contractual documents, where a person confirms the accuracy and authenticity of the contents of the document. Affirmation can also refer to a solemn declaration or promise made by a person under oath, affirming the truthfulness of their statements or testimony. 4. Attachment. Attachment in real estate refers to a legal process by which a creditor obtains a lien or claim against a debtor's property to secure payment of a debt. It is typically initiated through a court order and allows the creditor to seize and hold the debtor's property until the debt is satisfied or resolved. Attachment is commonly used as a legal remedy in cases of non-payment of debts or breach of contract, and can involve various types of property, including real property, personal property, and bank accounts. 5. Cessation of work. Cessation of work in real estate refers to the stopping or halting of construction or development activities on a property. It can occur due to various reasons, such as financial constraints, legal disputes, permit issues, or other unforeseen circumstances. Cessation of work can have legal and financial implications, and parties involved may need to take appropriate actions, such as obtaining legal advice, negotiating with contractors, obtaining permits, or seeking remedies through legal channels. 6. Declaration of Homestead. A declaration of homestead is a legal document filed by a homeowner to protect their primary residence from certain types of creditors' claims in the event of financial hardship or bankruptcy. It is typically filed with the county recorder's office and creates a homestead exemption, which can provide the homeowner with a limited amount of protection against forced sale or attachment of their home by creditors. Declaration of homestead laws vary by state and provide homeowners with certain legal protections to help safeguard their primary residence, which is often considered a person's most valuable asset. 1. General lien. A general lien is a legal claim against all of a person's property, both real and personal, to secure the payment of a debt or obligation. It gives the creditor the right to seize and sell any of the debtor's property to satisfy the debt, regardless of its type or location. General liens typically arise from court judgments, tax liens, or other legal actions, and they can affect all of the debtor's property until the debt is satisfied or resolved.